So for whom is it wrong to treat a child this way? For anyone, for everyone. And once you can come to the point of saying something like that, you're saying we are laying the groundwork for forbidding it. To whom? To anyone who commits the same thing, which is to say, we forbid it with the force of law. But there, in a nutshell, you might say, is the original classic understanding of the connection between the logic of moral judgment and the logic of law.
Join the best in the movement. It's Conservative Conversations with ISI, educating for liberty since 1953.
Welcome back. You're listening to Conservative Conversations with Marlo Slayback and Tom Saruf. Today we are delighted to welcome the legendary Hadley Arkes, who's the founder and director of the James Wilson Institute on Natural Rights and the American Founding. Prior to starting the James Wilson Institute, he was the Edward N. Ney Professor of Jurisprudence and American Institutions at Amherst College, where he taught for 50 years, assuming emeritus status in 2016. Arkes was also the architect of the Born Alive Infants Protection Act, which was a bill signed into law by President George W. Bush in 2002 and would protect babies who were born during a failed attempt at abortion. He's the author of several books, including First Things, Beyond the Constitution, Natural Rights and the Right to Choose, and now, with Regnery Publishing, Mere Natural Law, Originalism, and the Anchoring Truths of the Constitution. And for context for our listeners, I got to work with Professor Arkes as an intern at the James Wilson Institute. So I'm delighted to welcome him onto the podcast today. So Professor, it's great to have you with us.
And you were brilliant. There's no one like you when you were here with us. You have to try to find some way of stealing you from ISI. But anyway, that's another story. That's great. So nice to be
Not
with
yet,
you.
at least. And before we continue, we'd like to thank you for listening to Conservative Conversations. This podcast is a production of the Intercollegiate Studies Institute, and our mission is educating for liberty. If you'd like to join us in fulfilling this mission, please be sure to rate and leave a review of this podcast in Apple Podcasts. Help us reach more listeners like yourself. So I actually had the opportunity to meet you, Professor Arkes, a few weeks ago at a conference we had for students here in Delaware. Where ISI is based in Delaware. I'm not based in Delaware, but wanted to congratulate you for publishing your new book, Mere Natural Law. Thomas Spence from Regnery referred to it as your magnum opus. So we're excited to dig into it with you today for our readers. And for readers who are interested, by the way, there will be a link to the book in the show notes. So if you're interested, you can search out a link to purchase it there. So one question we often ask is what the motivation for writing the book is. But let's flip that on its head a little bit and ask, how have your debates and conversations within the conservative legal movement over the years and at the James Wilson Institute shaped how this book come together? And if you could also describe the work of James Wilson Institute as well for listeners who might not be familiar.
I did a book, a very important book called First Things on the Principles of Morals and Justice back in 1986 with Princeton. I thought that we need something different because so many judges thought that the natural law is some kind of a theory hovering overhead and not realizing that it just pervades everything they do, that it underlies everything they do, runs through. So, Thomas heard me use the line that to ask whether the judges could get through the day without using natural law is like asking the question, do I have to use the syntax when I order the coffee? It's always there. It's the law that underlies the law. And let's get back to that in a moment. You said with JWI, it was I had this offer to form a project in natural law, jurisprudence of natural law, about 11 years ago from Claremont. But it was my students, my former students from Amherst, who wanted to take it over, who wanted to sort of preserve my teaching and bring it to a wider audience. And we've been working with young lawyers and judges. In fact, judges and lawyers, older and younger, and ordinary folk, businessmen, for the sake of kind of restoring the understanding of the founders about the moral grounds of the law, the grounds of our own rights, and we're trying to impart to another generation those furnishings of mind of those men who framed this Constitution. We had a moment a little later, I could say, well, let's give some examples of those furnishings of mind. But first, my point was to get this out of the realm of some theory hovering in the sky, rather than understanding that the natural law provided the anchoring ground of our moral judgments. They were there. I appealed to my late friend Dan Robinson, who wrote 18 academic books, went on Aristotle's psychology, contributed to the neurosciences. And he said he wanted, as the epitaph on his gravestone, he died without a theory. And he was really calling upon Thomas Reid, the great Scot philosopher, with his teachings on common sense. It was read closely by James Wilson and John Adams and the others founders. And Reid would appeal to those precepts of common sense that the ordinary man not only had to know, not only could he grasp evidence quickly, but he had to take them for granted in getting on with the business of life. And there were things he had to know before he could start trafficking in theories. And Thomas heard me on this one. Before the ordinary man would start bantering with David Hume about the meaning of causation, he knew his own active powers to cause his own acts to happen. The American founders had the same beginning. They had the same aim. And it was so fascinating about the American founders, people like lawyers like Alexander Hamilton, John Marshall, is that they felt the need to keep making tracing their judgments back to explain to their readers what those anchoring axioms were as a way of laying the groundwork for the decisions in applying the Constitution to the cases before them. Those principles were there before they framed they drew upon those principles in framing the Constitution. They knew that those principles were there before the Constitution, and they knew those principles would be there even if there were no Constitution. Much in the way that John Quincy Adams would say that right to petition the government was simply implicit in the idea of a free society. It would be there even if it hadn't been mentioned in the First Amendment. It would be there even if there were no First Amendment. It would be there even if there were no Constitution. As I tried to explain to people a while back, there's some other angles on the matter since you and I have talked, Tom, that the natural underlies, it underlies all of our laws. It explains to us in the first case why we have positive laws on any subject. In other words, Kant would say, before you have positive laws, say speeding limits, 65 miles an hour, 35, there's an underlying natural law that tells you why you'd be justified in restraining the freedom of people to drive at speeds that put innocent life at hazard. And then, as ever, there's always a need to make a move from the principles of the natural law to apply the law to the circumstances before it and the terrain before us. And that's why the natural always needs the positive law in making a connection to applying the natural law to the circumstances before it. But it struck me in this way. If, say, the natural law would tell us first why you do have laws and why that biped who conjugates verbs is a bearer of rights. I mean, to talk about that, you have to have a sense of rights as opposed to wrongs. It implies standards of judgment. But this thing occurred to me, Tom, and I don't want to be too graphic for your audience, but in my book years ago, Philosopher in the City, I recalled a scene on Capitol Hill, kind of an X-rated things shown on the Hill by Judith Densengerber, dealing with the abuse of children. And again, I don't want to be too graphic, but she was dealing with the signs of sexually transmitted diseases in an 18-month-old girl and a 9-month-old girl. Now I thought we could present this problem to people, say, give us your natural reaction. We confront this case of a man using children in this way. And what is our natural reaction? Do we say, we'll give you a tax incentive to induce you to stop? We'll give you a DVD player. I don't think that's the reaction. I think the reaction is like a command. Stop! Stop doing it. It's the command. Stop doing it. What do we mean? It must be wrong. Well, wrong for whom? Wrong for whom? Only for this man? Or for anyone who does the same thing? In other words, it brings back out naturally a moral perspective. You're not simply, you don't want to make a contract with him. You want to forbid it. You want to say it's wrong. And when you're using that language, you're using the logic of moral judgment. For whom is it wrong to enslave another? It is wrong for anyone. Anyone. So for whom is it wrong to treat a child this way? For anyone, for everyone. And once you could come to the point of saying something like that, you're saying we are laying the groundwork for forbidding it. To whom? To anyone who commits the same thing, which is to say, we forbid it with the force of law. But there, in a nutshell, you might say, is the original classic understanding of the connection between the logic of moral judgment and the logic of law. Aristotle says the polis springs distinctly from the nature of one kind of creature. The mark of the polis is law. What is there that's distinctive to human beings from which that law springs? The capacity to do more than emit sounds to indicate pleasure and pain, but to give reasons over matters of right and wrong. So why the mystery? Why do you how do we find ourselves going out into a period where we find a class of lawyers who think that every time we raise a question of the moral concerns of the law, we're dealing with something that's kind of extrinsic to the law or tertiary, not central to the concerns of the law. So that's what we engaged. I thought the best thing was to do was to engage it at that level, where ordinary people readily understand the. You know that line of Jefferson's where he said, "You can give the same moral problem to a professor and a plowman, and the plowman is apt to get it right, for he'll not be distracted by artificial rules. Call them theories." You remember, I used the example, this came up in a conversation this morning, I don't know if it's worth recalling to time, that with C.S. Lewis, you'd say, that's mere natural laws drawn in part from that sense of things in Mere Christianity, where he would say, on the conversation of children, you see they're having an argument. It's not over likes and dislikes, it's a matter of right and wrong. And they imply a conversation makes no sense unless you assume their standards of judgment, telling the difference between right answers and wrong ones. Okay. And some of these things are accessible to young people, where older people lose the sense of it. The one that I offer to Tom knows, this came out in the conversation this morning. Imagine a 7-year-old who's beaten up at school by people who steal his lunch money. And we ask, which of these would you think would be his reaction to it? One, that he was wrong. He was beaten up and wronged. He suffered a wrong. Or second, well, those people who beat him up, they're probably right because they succeeded. My reading is the second one is utterly implausible. That any kid would problem with the first one. But in that case would say the youngster, the 7-year-old, understands that riveting point that Rousseau made his critical point in the social contract. The mere success of some people in seizing and holding power over others cannot establish its own justification, as though brute power establishes its own justification. It's the rule of the strong. Might makes right. And so Rousseau says it only depends for us to acquire might. He said, but what validity can there be in a right which changes hands as soon as might changes hands? So I think the 7-year-old, in grasping that point, that he was wrong, grasped that point of Rousseau's. But in grasping it, he understands something that invaded the understanding of Justice Holmes. Because the question was put to Holmes, on what ground does the majority in a democratic system rule the minority? Holmes's answer was, because it can overpower the minority. The rule of the strong. Might makes right. And regrettably, that judgment was held by my friend Justice Scalia as well. And we said, well, this country did not begin with the seizure of power. It began with the conviction that the only rightful government is that whose powers are drawn from the consent of the governed. And Lincoln, in his first inaugural, it's a remarkable address for many reasons, but he often shows us what is the operational form that is compatible with government by the consent of the government. It can't be the rule of a minority. It must be the vote of a majority, but a majority that understands it's working under moral and legal restraints, that it's not free to decide just any damn thing, He said, that is the only operational form of the rule of the majority. Now, my friend Scalia would say, well, that's never been enacted in our law. And the point was, John Locke brought this out nicely, but of course it could not be enacted in the law, because it had to be in place for us to understand what is the Constitution that would be a legitimate form of law for us. Remember, I was in a meeting with Professor Amy Coney Barrett years ago, and somebody must have been picking up something I did and asked her, well, you want to rely on the positive law? Why are we obliged to respect the positive law? What makes the positive law in America different from the positive law in Stalin's Russia? It can't be because it's enforced. It must be because the positive law in America emanates from a system, a principle that establishes who has the rightful authority to make that positive law. Remember, Locke had it in this little string of three questions. What is the source of the law? The legislature. The next. Well, what is the source of the legislature? Well, Constitution. It tells you whether you have a legislature, how many chambers, what powers. But then he asked, but what is the source of the Constitution? Where does that come from? He said it must be to some principle antecedent to the positive law. Okay? The principle for us was all men are created equal. No man is by nature the rule of other men. If you find a situation with some men ruling over others, that situation cannot arise from nature. It must arise from consent. Barack Obama was too sophisticated to think all men are created equal was a real truth, let alone an absolute truth. Lincoln and Madison did think it was an absolute truth because it was anchored in an enduring nature that separated human beings from other animals. It established why human beings by nature cannot be the rulers of human beings the way they're rulers of horses and dogs. And Tom will remember that line of Jefferson's where Jefferson said, anyone who denies that has to assume that the mass of mankind were born with saddles on their backs, and the privileged few were born with spurs on, ready to ride them. Now, that is something ordinary people understand, if you put the question. I say, we do put the question to people, why do you think, this age of animal rights, we're still not signing labor contracts with our horses and cows? or seeking the informed consent of our household pets before we authorize surgery on them? The ordinary man would be baffled by that question, and he'd understand why. That it makes no sense to speak of making a contract with a creature who's incapable of communicating by giving reasons, or, as Thomas Reid said, a creature who's incapable of making a promise, pledging his veracity, pledging his faith. There's only one kind of creature, as Aristotle would tell us, who's capable of making a contract, undertaking an obligation, and respecting that commitment, even when it runs counter to his interests. Okay, so I think the ordinary man would grasp that right away, which is to say, he grasps the essential point of the Declaration. No man is by nature the rule of other men, in the way that men are by nature the rulers of dogs and horses, and the oldest saying was God was by nature the ruler of man. So there's nothing mysterious about this. And as I point out, and Tom knows that ordinary people, you find this in the conversation of ordinary people. Several years ago, my wife and I were put out of our building, along with our neighbors, a wonderful apartment building, because the fire department was fighting a fire. Our liberty was restricted. We put out for a couple. Everybody was vexed. No one was happy with it. Our liberty was certainly restricted. Our liberty to return to our own apartments. Yet nobody thought our rights were being violated. Our liberty was restricted, but nobody thought the rights were being violated. Why? Because they understood that those restrictions were animated by the purpose of protecting innocent life. There's justification for it. I see a youngster poised on Connecticut Avenue, ready to take a bicycle down into the subway, and I say, how can you do that? And he says, yes, but not during rush hour. He understands that it would be utterly unreasonable to take that into the rush hour filled with people, like taking up the room of 2 or 3 other people. In other words, he understands his liberty is being restricted for reasons that are patently justified. My point is, this is the way ordinary people make these decisions every day. It's quite natural. There is nothing inscrutable about them. It's so you think, well, we're not offering here anything that's just beyond our ordinary human experience. And the point is that sometimes these things depend on principles so woven with common sense that we're hardly even aware that you were using them. So now the question is just maybe what can we do by making people alert to the fact that they use them, that they're there? And if what difference does it make if we now suddenly become aware of what we're using, or if we begin to look at our experience through the lens of the natural law? You remember that old time with the philosopher Wittgenstein asking his student, Elizabeth Anscombe, why is it that people in an earlier day believed that the sun revolved about the earth? He said, no. She said, no, because it looked as though the sun revolved about the earth. And he said, well, what do they think it would have looked like if the earth were revolving about the sun? So now we're saying, look, you think that morality is utterly extrinsic to the law. What do we see anew if we come to understand that morality is the logic of morals pervades the law? What might we see anew?
Well, on that note,
I'm doing a lot of talking. My goodness. Okay.
No, that was fantastic. And it's raised so many different directions we could take the conversation in. But one question that comes to mind, and you mentioned Thomas Reid a number of times, and I thought, the earth revolving around the sun, or vice versa, example, because when Reid talks about common sense, these sorts of intuitive things that everyone knows that appeal to children, people who are unschooled in moral philosophy, say, I recall reading in the Prolegomena to Any Future Metaphysics, Immanuel Kant critiques it, calling Reid's ideas prejudice built upon stilts. He's trying to fabricate reasons for
that sounds like Bentham criticizing natural rights as nonsense on stilts.
That's right.
You sure got one from? Okay, that's.
I think I don't. Maybe he doesn't call it prejudice upon stilts. He calls it pure prejudice. But for Kant, you need reasons, and you're pointing to this as well, is that you need a principled basis of justification for laws or for making certain distinctions in a way that's just. So how do you fit Reid and Kant together when Kant would have seen it as his and Reid's ideas as opposed?
Well, Dan Robbins, who was lecturing on Kant at Oxford, said that Kant really misunderstood Reid. He thought Reid was offering like a mind shot. It's like the wisdom of the herd.
Right.
And that's not what he was doing. Part of what it runs deeper. He was saying that one reason the common man understands, the common man could see billiard balls knocking against billiard balls for him, but it's the fact that he understands that he himself can cause his own acts to happen, which allows him to see the whole thing set up as a relation of cause and effect. Kant is. Well, it's I don't know why people sort of deny the standing of Kant as a natural law theory. Kant tells a number of things. First of all, he said all moral principles can simply be drawn out of the very idea of a rational creature as such. It's all there. What are the laws of reason? Why are we obliged to respect the law of contradiction as a law of reason? I can violate the law. I can be inconsistent all the time. I can make mistaken calculations in my checkbook, and the ceiling doesn't fall in on me. What makes these laws of reason laws? The answer is because they command our respect as laws of reason. And you virtually have to talk yourself into nonsense to refute them. So let's take that very first principle that Kant as well as Reid took as the very first principle of all moral and legal judgment, that it makes no sense to cast moral judgments of praise or blame on people for acts they were powerless to effect. So Kant would say, well, that is simply a law of reason. Why would you respect it? Because it commands your respect as a law. It's intrinsically true. And that's the ground on which the argument is made. And Kant would also tell us A unanimity of judgment, a unanimity of feeling cannot supply the ground of a moral judgment. If we're all unanimous, all in favor of the Coca-Cola, that would not give us the ground for making the Coca-Cola compulsory. Because your feelings on Coca-Cola may change today or tomorrow. But that proposition, we don't hold people blameworthy for acts they were powerless to effect, that will be the same tomorrow as today. And Kant was telling us that to have a moral proposition, you needed something that was anchored in the law of reason. So if you said, where in the world would it cease to be true that you don't hold people blameworthy for acts they were powerless to effect? The answer would be nowhere. It's true everywhere the laws of reason are intact, and we have creatures of reason who have access to them. So when he uses the categorical imperative, he said, those maxims fit to be installed as a universal rule because they are universally valid. They're fit to be installed because they're universal. We're not saying, it's like, we're ready to universalize a perverse maxim, like the conscientious Nazi who's willing to go to the wall when he discovers that he himself has a Jewish grandparent. I honor the principle, and I'm willing to apply it even to myself. That's simply your willingness to universalize a perverse maxim. That is not the test. The question is does the maxim itself have the standing of a necessary truth? So that, of course, it would be valid in all places. That's a good point. I think Kant is truly misunderstood. I saw some lectures, but even one of your foreign professors, I said, Kant, there is no truth, and so on. I said, once I imagined, you try yourself, a South Sea island in the 18th century, a British ship pulls up, and the natives see their 3 sailors come on shore, and the natives see them. Now the question you don't know anything about the culture. Do we think the natives would understand the difference between this and this? They can see the difference between 3 people there and 1. Then must be they are aware of the concept of number. One guy with a pistol shoots and fells a native. Do you think that the natives would understand cause and effect? Someone caused something to happen, and if anyone's to be held responsible, that one should be the object of their passion and their anger. So Kant gives us the grounds in which to understand what is there in the world, which almost everybody has to understand. And I quarrel with those people who put him outside the realm of natural law. At so many places I find myself. He warned us against the tendency to simply arrive at an understanding of human nature by just generalizing about the checkered record of our species. So you have one jurist, Dick Posner, who said, well, incest and infanticide must be in accord with natural law because they seem to be an intractable part of the human experience. And Kant said, no, it is not it's not a generalization of what human beings have done. It's a matter of extracting what is distinctly human and those laws of reason that are accessible only to a creature constituted this way, as a creature of reason.
So to pivot a little bit into kind of a more concrete...
I thought I have been concrete, I'm talking about.
Something that I think some of our listeners might be able to, perhaps who don't have a background in jurisprudence or a legal background, might be able to relate to just based off of what they've been seeing in news reports and following, just from the courts today and the political atmosphere and landscape. And because the beginning of your book actually catalogs the morass in which the legal realm finds itself today, among both liberals and conservatives. So if you could give us some background context there for how have, the liberals untethered themselves from America's traditions of jurisprudence and what the conservative response has been.
Well, there seems an inclination to sort of bring into the Constitution everything on the liberal agenda. And of course, the most important thing has been sexual liberation, to liberate your sexuality from any strict meaning of what sex means. And there's a moral framework for sex that it makes a profound difference if sex involves a committed relation of two people that they beget children, and there is a framework of commitment so that the child understands that the parents have foregone their freedom to quit that association with him as with others. There's a real meaning to sexuality. Sometimes I think people can concede through a joke what they will not concede in an argument. Like Rodney Dangerfield saying years ago, I was afraid the first time I had sex. I was afraid because I was all alone. Well, the laugh there marks the fact that even if the two people in tandem replicated the masturbation implicit in the joke, it'd still not be sex. We know what the strict meaning of sex, why are we constituted as males and females? The Congregation for the Doctrine of Faith, when Carlo Ratzinger once there was said, there's not always been in Italy or Hungary. But as long as there are human beings, there must be males and females. That is the telos or purpose. That is why we are constituted as males and females. So we have a case, you see, on transgenderism. The Supreme Court. People say, well, if Anthony Stevens thinks he is truly a woman, then the rest of us are obliged to respect it, or else we engage in discrimination. And the conservatives, the liberal position is simply to remove all kinds of moral restraints, even to disconnect sex from any firm, objective understanding of what sex actually is. That's how you liberate sexuality, for all kinds of restraints and commitments, and the moral framework in which sexual relations between a man and woman may take place. And the conservatives faced this question, and they said, well, we don't know if it's sexual discrimination. We have to see what the civil rights, how they understood this matter in the Civil Rights Act of 1964, or when they finally barred discriminations based on sex. And what seemed to be ruled out of the conservative line is that you appeal to the objective truth. Go beyond the statutes and appeal to the objective truth. And that's what has been ruled out of conservative jurisprudence in our own time. The conservatives have seen liberals appealing to these grand principles outside the text. Instead of saying, well, they're specious and false, the conservatives say, no, the real vice is that they're appealing to something outside the text. And the conservative line has been, once you're moving outside the text, you're looking inside yourself. What the conservatives have fallen into is the assumption that once you leave the text, there are no moral truths outside the text. Well, the founders really rejected that. They're persistently appealing to those anchoring truths outside the text. This is a fixation that conservatives have taught themselves. They've recoiled from liberals, inventing new rights, extravagant new rights. And instead of countering the reasoning behind it, trying to refute the reasoning, they've said, you see, your vice was that you were using moral reasoning. And we'll counter that. We'll show you that we won't use moral reasoning at all. Okay? And it's just, of course, it hasn't worked. It hasn't produced any safety for the conservatives, and it's pushed conservatives into a position where they seem to hold that it's just inapt for a judge ever to appeal to a deeper truth outside the text, so that when we do the case on abortion, the Dobbs case, it was a critical point for the conservatives forming the majority, that they would not pronounce on the human standing of the child in the womb. I mean, 50 years ago, lawyers from Texas, in Roe versus Wade, offered an exquisite brief, drawing on the most updated findings of embryology to show that offspring in the womb has never been anything other than human in its first moments, and never merely part of the body of the mother. But the conservatives take the line that, no, We can't say that. We'll have to leave it to people in the political arena to draw their own conclusions. But in the meantime, in holding back, they've deprived the pro-life movement and of a critical premise. If they return the matter to the states, if they establish that, of course what we're saying here is the evidence is compelling. They were dealing with the taking of a small human life. Small, it's just, however small it is, whatever it looks like, it's still what you looked like when you were that small. And if you establish that point, you have established the predicate on which the Congress can come forth and say, we can invoke the 14th Amendment when the protections of life are withdrawn from a whole class of people in the blue states, namely unborn children or human beings. Well, that would have made a profound difference. But we find that the conservatives, for some reason, have taught in their reaction to liberal interventionism, their expectations to just cabin things and close down and try to deny the rightness of conservative judges appealing to moral principles outside the text. And they've given us this kind of constricted positivism and a jurisprudence that finally can't give a coherent account of itself. You're saying, oh, you're returning the issue of abortion to the states. Here's a woman who thought she had this very serious right of abortion bound up with her personal freedom. You're taking it away from her. You're taking it away from her when 51% of the people around her have a different opinion. How does that explain anything? And why should people not feel aggrieved when something, if that's all you can say? Why should they not then appeal to the national government for the sake of coming in to protect them in their right to an abortion? Well, the conservatives have made it harder for the national government to enter for the sake of protecting those small units in the world. That national power is going to be used. It's going to be used either to protect those unborn children as the laws withdraw the protections of the law, or it's going to be used to firm up the right to abortion, the right to end those lives. There's been no way of getting it wrong. But again, I guess it was a circuitous response to your question, but it's a matter of liberals seeking their ends by removing all sense of moral restraints from the liberal agenda, and the conservatives responding by finding the fault in using moral reasoning altogether, instead of engaging the moral reasoning directly, the substance of the matter head on to counter that. Instead, retreating to these positivist formulas. The question is, abortion is not in the text of the Constitution. Therefore, federal judges have nothing to say about the matter. Well, marriage was not in the federal Constitution when the Supreme Court struck down those laws in Virginia that barred marriage across racial lines. And as my dear friend Jerry Bradley at Notre Dame pointed out, the federal government has long had reason to deal with the business of abortion, whether abortion in military hospitals, diplomatic outposts abroad, abortion in the territories of the United States, the District of Columbia. It can't be because abortion was simply not in the text of the Constitution that the federal judges have nothing to say on the subject. Now, what you see here is a story of a kind of positivism turning in on itself, concentrating on the text, denying that there is, to the point of denying that there are truths outside the text, or denying that we can indeed appeal to objective truths outside the text for the sake of giving us a coherent judgment in this case at hand. Even understanding what the case is about. How do we understand what the case is about if we're not raising the question, is that or is it not a human life? Remember Lincoln's line about the question before us is the black man not a human being, or is a human being? That's what the whole thing may depend on. Right? And the same thing happened with the question of this human standing of the child in the womb. The conservative judges did not want to address the question. But if you're not addressing it, we don't have a clear sense of what this issue is even about.
So it sounds like the liberals have gone off and done whatever it is that they want to do that fits within their agenda. And the conservative response has been to try and recapture the liberalism of Justice Holmes, who wanted to extract, and I learned this from you, who wants to extract all moral reasoning from
Yeah, we
the
should just
law.
try to avoid that moral. We have to purge all this moral reasoning from the law altogether, and give us a law that is pure now. That's pure law. That it's not infected with this moral reasoning.
Well, Professor, unfortunately, there's so much more to discuss, but we're coming to the end of our time. So let's finish with this.
Wait, have I given Marlowe something concrete enough? It's like, can we do one quickie?
Yeah, let's try with this. What would your advice be to our listeners for how we can recover the natural law, and not only in our jurisprudence, but also in our reasoning and in our daily lives? Because it seems like ideology has become so pervasive. Like when you were mentioning Bostock, the telling point was when Justice Gorsuch assumed, or sort of took as a matter of fact, that Anthony Stevens could become Amy Stevens. But that's not a commonsensical position in the way that Reed understood it, or the way that any person would. That's not common sense. So what do we do?
Well, how would the ordinary man understand it? This woman thinks she thinks of herself as black. That didn't make her black. The guy says, "I think of myself as 6'2", and the ordinary thinking it doesn't make you so. And the ordinary man look at this and say, he is not a woman. And those guys wanting to go into the women's locker room, no, they're not women. The ordinary person would just have the common sense view of the matter. In other words, you have to have the experience, maybe in law school and higher education, of talking yourself into ingenious theories that give you another angle on the problem. Theories that would not fly with the ordinary man who just looks at the world before him and can say what it is. So and the other part is really reading again those critical papers, those writings of the Federalist Papers, or James Wilson's lectures on law, or John Marshall's writings in his cases. They show us how to do it. They show us how they did reason about the matter, and it's there to be studied and learned anew. But it's not so inscrutable. I mean, the furnishings of mind are just there to be seen.
Well, Professor, on that note, the book is Mere Natural Law.
That'll help. The book will help.
There we go. We will link it in the show notes. And if there's anywhere else for people who they want to follow more of your work, where should they look? Where can they go?
Oh, let's see. I know. Well, go to our web. You help arrange the website at the James Wilson Institute. They'll usually put on almost everything I'm writing. There are my other books, Constitutional Illusions and Anchoring Truths, First Things with Princeton, Natural Rights and Rights. They can just check Amazon for my writings, but also check First Things, the journal. They borrowed the name from my book. Father Newhouse borrowed the name and the font. And they had to put me on the board. And I still, so many people know me through the writings I've had in First Things, the journal. And so did I ever tell you the story about Ralph McInerney? We don't have time for this. Okay. Ralph McInerney putting me in his one of his mysteries. Ralph McInerney, who is philosophy professor at Notre Dame, who wrote all kinds of mystery novels. He called me and said, I'm in a mystery. I said, really? Do I solve the crime? No. Not the murder one, am I? No. He said, it's a cameo. What's the cameo? It's a gal who used to work for First Things, the journal. She's working for the Vatican. And a reporter from New York gets her in a cafe and he says, tell me about First Things. And she said, oh, you mean that book by Hadley Arkes?
Hey, there you go.
That was Ralph McInerney coming down on my side. So anyway, thanks so much for taking the time to have the interview and hold the conversation with me.
Well, thank you for joining us.
I look forward to doing more with ISI. It was a great organization. It's become renewed as a great organization. And many good things to come from it, with you two at the center of it. So thanks again.
Thanks so much, Professor Arkes, and hope to be involving you a lot more in the future as well. So really appreciate your time today. And we'll link your book in the show notes. So if you're interested in purchasing Professor Arkes' book, it will be attached to this podcast. And I also wanted to thank our listeners today for listening to Conservative Conversations with ISI. If you've enjoyed this podcast, be sure to head over to isi.org/resources, see all that we offer our members, including Intercollegiate Review, Select Modern Age articles, and of course this podcast. Would also like to invite all of the people listening to our homecoming event, which is coming up in early June. So please go to our website to hear more about that, which will be held in Wilmington, Delaware at our beautiful mansion headquarters. And please also rate and review our podcast, and we'll see you next time on Conservative Conversations with ISI.